Diamante Kendrick. But again, can I go through a rundown here? But again, the lots of new motions filed today in the YSL trial. Diamante Kendrick, who's right here, his lawyers, Doug Weinstein, who we've heard from, has requested bail, and they've also requested a mistrial. And then, interestingly, prosecutors have actually moved to have Judge Whitaker tell the defense they can no longer make public statements. They're citing all the interviews that Doug Weinstein, Max Schardt, Keith Adams have done with me, Sylvia, different public statements that they've made, in saying that this violates Georgia's judicial rules regarding extrajudicial statements being made, but particularly in criminal cases, they say it's a problem. They don't really get into many details about specific statements they have issue with or why these statements are a problem, but they're basically asking for a blanket gag order that would restrict any public statements moving forward. So that was among the motions filed today. I expect the defense will file a response to this by the deadline end of Friday in Atlanta. And then again, they are back in court on Tuesday, July 30th to start going over all this stuff. 8:45 a.m., as Judge Whitaker made clear, that's 5:45 a.m. here in California. But she's got a lot to really decide. And really, while the motion complaining about the public statements is one of the more interesting ones, it's probably the least substantial in terms of what will actually affect the trial. I mean, we've got some motions for mistrial that are substantial, also motions for bail. We've got the motion that was filed last week for Marquavius Huey, and then we've got Diamante Kendrick's motion for bail, and then Brian Steele and Keith Adams also filed a motion for bail on behalf of Young Thug. So we've got a few things to really look into here. And the judge, I mean, this is going to be the first real test for the judge come Tuesday morning, is how is she going to respond to some of this stuff? It's such a big question of, is she going to be willing to revisit that ex parte meeting on June 10th that, remember, is what started all of the recusal motions, but it's actually not the basis for the judge's recusal. The Judge Krause, when she recused Judge Glanville, even said in there that she generally agreed with his assessment of the ex parte meeting, but her problem was, and Glanville's problem started with when he was defending himself against these recusal motions. And this wasn't even an argument that was raised in the recusal motions against him. The judge went out and found her own reason to recuse him. But case law in Georgia is pretty clear that judges are not supposed to defend themselves when a recusal motion is filed, a public defense. And one case even says that the public defense against the recusal can then become the basis for recusal. So that's what happened to Judge Glanville. So overall, the recusal was a huge win for the defense, but there's stuff in that ruling that isn't helpful for them, in that Judge Krause says that she generally agrees with the propriety of the June 10th. And then she includes a line like divorce from hyperbole when she's describing Brian Steele's motion for recusal. So Brian Steele has asked Judge Whitaker, the new judge on the case, to reconsider those rulings by Judge Krause. So those are that's the biggest. Obviously the mistrial would be a bigger deal, but if Brian Steele can get Judge Whitaker to reconsider those rulings and make a finding that the ex parte was wrong, and that the prosecutors were wrong to conduct this too, that increases the chances that, okay, there's a prosecutorial misconduct finding. Could there be a double jeopardy finding if there's a mistrial? That's it. It kind of lays the foundation for everything else. Like I said, it's hard to say what she's going to do, but I just think with Judge Krause being the judge that made those rulings, and she not really being dirtied up in this case at all, like there's no reason to question, her rulings on that I don't know if Judge Whitaker is going to feel comfortable like going back and redoing that decision. But the one other test that Max Schardt is asking for here is for reconsideration of the ruling regarding the admissibility of hearsay from Little D regarding Donovan Thomas's murder. Because remember, a big part of why they called Woody to the stand is he just sang like a canary back in 2015 and really gave all this stuff that prosecutors were kind of just treating as the gospel and just counting on the fact that Woody was going to get up on the stand and just say all that kind of stuff again. And back in 2015, Woody told the cops that little D and Shannon had gotten into a car with him after Donovan Thomas's murder, and that little D had said something that basically confessed to Donovan Thomas's murder. But the problem is, I mean, anyone who's seen Woody's interviews knows that he's not backing up those statements now, and he's just saying that he was lying and he was doing anything he could to get out of it. So Max Schardt's argument is in this new motion is that the Glanville was wrong to say that those interviews from 2015 could be admitted in court, and that prosecutors could ask Woody about it, because Glanville had said that they were part of a co-conspirator statement, that they're hearsay statements under co-conspirator rule. But apparently the case law on co-conspirator hearsay is it has to be more than just, I did it. It has to be something that actually furthers the conspiracy. That little D supposedly getting in the car and confessing isn't anything that they did to further the conspiracy of murder or YSL or RICO or anything like that. Yeah, somebody said she recused him for public trust of the case, but yeah, that's what she said about the public statements, because it was based on the public statements that the judge made, but she cited public trust in the judiciary, because she even said she had no doubt that he could consider he could continue presiding over this fairly. But when you look at the Georgia case law on judge recusal, it is really clear, and there's some past cases where judges have really gotten in trouble for defending themselves, for publicly defending themselves, and that's exactly what Judge Glanville did. If you go back and look at the video from July 1st when he sent them to another judge, the headline on my video, I made it Judge Glanville defends ex parte, because that seemed like a pretty accurate description of what he was doing. So it'll be interesting to see what Whitaker does in terms of the ex parte. She'll be pretty safe to just stay away from offering her own assessment of it and just saying that, look, another judge has already decided that, we don't need to revisit that. But these requests also kind of open the door for her to possibly really piss the defense off by saying that she doesn't see a problem with it either. I think she's smart enough to just stay away from that. If she doesn't need to say anything like that, why do it? But here, let's bring up and I don't know if you guys are on Twitter, but if you're looking for a good way to just stay up with the documents, Thugger Daily, who's kind of risen to prominence on here, he and Joseph posted a lot of I think all of them, the documents